So this is part of a series of podcasts on implementation of human rights decisions. I'm Rachel Murray, I'm Director of the Human Rights Implementation Centre at the University of Bristol in the UK. And we examined, as part of an ESRC grant with colleagues in the universities in Essex, Middlesex and Pretoria, and with the Open Society Justice Initiative, whether and how state authorities implement recommendations and reparations adopted by regional and international treaty bodies, including among these the African Commission and African Court on Human and People's Rights and the UN Human Rights Treaty bodies. I've got the privilege of insights here today from Gaye Sowe. Gaye was also on our advisory board on the project, and he's Executive Director of the Institute for Human Rights and Development in Africa and an expert member of the African Commission's Working Group on Economic, Social and Cultural Rights. Before joining the Institute, he worked for the Gambian Judiciary as First-Class Magistrate, Senior Magistrate, Principal Magistrate and Chairman of the Banjul Industrial Tribunal, and Acting Judicial Secretary. He was called to the Gambian and Nigerian bars, and he is a member of the Constitutional Review Commission of the Gambia and part of a team of 3 lawyers currently reviewing and redrafting the criminal justice laws of the Gambia. So Gaye, thank you very much for doing this podcast. One of the things I'd like to start by asking you is that one of the issues that our research found was that a factor that might have an impact on the extent to which reparations may be implemented is how they are drafted and decisions made during the preparation of the submissions on the decision, so prior to actually the decision being adopted. In your extensive experience, what do you think litigators should be thinking about during the preparation of submissions on a communication in terms of how they will then subsequently be implemented?
Thank you, Rachel, for having me. I think it's important as a litigator to have the remedy section of whatever is it that you intend to work on. It's important to start thinking about it from the get-go. In other words, from the time you putting together your evidence, from the time you interview witnesses, it's always important to get a sense of what the witnesses want out of the whole process, and doing so would help you frame very good arguments, it would help you frame a very good section on reliefs, as in what is it that you want either the commission, the court to do for you. Unfortunately, there is a tendency to start thinking about reliefs or remedies from the time you start drafting, which in a sense could be too late. So it's important you have that factored in from the get-go, get a sense of what the victims want, and also get a sense of what is possible, what is easily implementable, what will take time to implement. So I believe having that in mind at the get-go would really help in framing very good arguments on remedies. So I think that is really something litigators should have in mind.
And what about the difficulties of, obviously, when you're submitting these issues, then it's often years in advance of when the case is actually decided, and so the circumstances may have changed, the wishes of the victims may have changed. How do you manage those difficulties?
That is particularly important with respect to cases that are before the commission, because for the commission you have to go through 3 different stages, from seizure to admissibility to the merits. But again, because you really don't have control over the process, not having control in the sense you would submit your you would submit your seizure letter, wait for the commission to get back to you before you get to admissibility, and then after your decision is taken, you then would be required to submit your decision on the merits, which would take a few years. I would say, irrespective of how long it takes, it's always good from the get-go to get a good sense of what you want out of the whole process, which is very much related to the point I made earlier. For a court such as the ECOWAS court, it normally wouldn't take that time, in the sense you're allowed at the time you submit your case to to put in your arguments, as in you front load everything. Because for ECOWAS, you don't have to, come up with arguments on admissibility. It's just about putting in the merits of your case and, of course, making clear what is it that you want from the court, as in the release you're seeking. Mm-hmm. So under those circumstances, it wouldn't take you 3-4 years, to get to the bottom of to get to, submitting your arguments on the release you're seeking. I would say this, the African, in the sense, for the African court, you send in all your documents at the time you file your case. Mm-hmm. So which means you would have to have in mind, your release from, the time you start working on the case, the time you start drafting. And of course, when you submit, you have to make sure you submit them. So in a sense, it wouldn't really take, for those courts, it wouldn't take 2-3 years for you to get to, submit your release to the court. But for the African Commission, it could take longer.
Sure.
But then irrespective of whether you're going to the Commission, you're going to the court, irrespective of how many years it takes, because, memory fades. Sure. We would say whatever it is, you have it captured from the get-go, so that at least if maybe witnesses move on, or if maybe there are cases changes as to the facts and circumstances, you would have been clear from the get-go as to the release you believe you should be seeking in your case.
Mm-hmm. Okay, that's really interesting. And so once the decision is adopted, whether it's by the African Commission, the African Court, or whoever, and that it's got a list of reparations or recommendations the state should implement to address any violations, can you talk us through some of the challenges that you faced in trying to then ensure that the decision and those reparations are actually implemented?
For me, the biggest, is maybe political will. If the government is willing, normally it really wouldn't take time to get these decisions implemented. I can give a good example of a case we recently won against Mali. I mean, the plaintiff in the case, it's a case before the ECOWAS court, was awarded compensation of about 15 million CFA, and we were told a week or 2 weeks ago that the state has gone on to pay her, 15 million CFA. But so it means normally when it is about money judgments or decisions involving money, the issue is usually straightforward. But when we litigate, that's at HRIC, we try in most cases to go beyond just money judgments. We would in most cases request for structural remedies, which are, I think, the most difficult to implement.
Yeah.
In this particular case, the state has no problems paying the money, but there are other orders it is yet to comply with. For example, giving the lady who was a victim of domestic violence, who was a victim of gender-based discrimination, as in allowing her access to the husband, that the state hasn't complied with yet. Another case we've dealt with before the commission, the famous Kilwa case. In that case, the commission came up with a lot of very good structural remedies.
Yeah.
But until now, the state hasn't gone on to implement. So I would say, if it is clear-cut, as in, whether the commission, the court saying XYZ should be paid $1 million or so, there is usually no problem in the sense the decision is really very clear-cut. It's just about bringing out the money, paying over. But when it comes to, certain changes, as if, for example, if if the decision involves changing a particular law or something like a memorial or something of that sort for the victims, those ones take a bit of time. In the sense, they're not always very easy to implement. But I would say, irrespective of how difficult, at the end of the day, if the political will is present, you normally wouldn't have time. You have problems getting them done. So, clear-cut cases, I would say, very straightforward. But normally when it comes to adopting structural measures, we always encounter problems. Some of them not always implemented, some even if implemented, not done according to the way our releases are, framed, or not done according to the way is actually adopted by any of the mechanisms before which we litigate.
And do you think it's just about political will? And if so, what does that mean when you are looking at things like reparations or recommendations that require amendment of legislation, so therefore it involves the legislature or some involvement of the judiciary, where it isn't so much up to sort of the actual executive to do something, it's other arms of the state. And you mentioned the Kill decision, which has been sort of held up as a very innovative way of trying to ensure implementation and having a if you could talk through some of the things that tries to do to try and set a process, I suppose, in place at the national level to try and facilitate implementation.
Yeah, the decision requires the government to set up a committee
Yeah.
that will monitor implementation. But we know that hasn't happened. I can understand a decision involving, a change in the law. Of course, here we would expect the National Assembly or maybe the legislature to take charge, But at the end of the day, what maybe we need to push for is for all our states to really identify a particular institution that would be responsible for implementing some of these decisions. I'm talking about the international decisions, so that at the end of the day, with a decision going into a country, you really wouldn't be running around chasing shadows. It will be clear to you as to this is the particular ministry I have to go to. It could be the Foreign Ministry, it could be the Ministry of Justice. So it means even if it amounts to, changing a law, you wouldn't be in a position to meet all parliamentarians.
Yeah.
So it's just about making sure you go to the relevant government ministry, which would be in charge of making sure the decisions are adopted. So I feel, doing it that way, or maybe going by what the Commission recommended, because, for some, in some instances, you will realize the recommendations are not always clear. They sometimes very vague. But if you come up with a recommendation, such as those you have, set up a committee, I think that really would make it a lot easier for the victims, for those of us who litigate, and even for the state. So, setting up such a committee, as recommended by the African Commission, or in a case where a particular government ministry is saddled with the responsibility of implementation, that really makes it easy in the sense you now would know what to do, who is responsible for what. We hope, that is done, particularly for us, the cases we're working on, because that would make life a lot easier.
Yeah. Okay. That's really interesting. And just finally, what support do you think organisations like yourselves need to assist you in monitoring or facilitating the implementation of decisions on the cases in which you've been involved, whether this is the Kilwa case or others?
Wow, that's
a big question.
The thing is, we are a small organization, and as lawyers, we're good at litigating. Implementation is a lot more than just, lawyering skills. A lot of advocacy is needed. And to be honest, those are not the kind of skills you build overnight.
No.
You really would, dedicate a lot of time, dedicate a lot of resources. So I would say we definitely would, benefit from a lot of these cases if the decisions continue to be clearer, as in specific recommendations that are maybe possible or maybe easier to implement. I think that would really, really help us. And I think too, we also would expect the mechanisms, if possible, to come up with a follow-up process. So don't just make an order, don't just make a recommendation. You should find a way of at least following up on whether the recommendation made was implemented or the order made was complied with. You don't get a lot of that, unfortunately, before these mechanisms, because I can give an example. Since the Kilwa case was decided, nothing exactly has moved. Of course, we've been doing our best as civil society, writing to the state, writing to, persons we believe might be able to help. But like I said, we're small. important. So probably if the Commission comes up with follow-up, procedures, maybe that would help in making our work a lot easier. Unfortunately, that is missing in some cases.
Okay. Thank you so much for your time, Gaye, and for all those invaluable insights, which I'm sure people listening to this will find extremely useful. Thank you.
Oh, okay. Thanks for having me.